Welcome back to Retirement Decoded with Scott Tucker. I'm your host, Scott Tucker. Today we want to talk about legacy planning. Legacy planning, some people say estate planning. What kind of legacy do you want to leave maybe to the next generation and maybe the grandkids, or just maybe you don't even have children. You want to leave some sort of legacy maybe to the community, to charities that you care about, that sort of thing. So a couple of things about legacy planning. I want to ask you, do you have a will? If you don't have a will, that would be probably a number one thing you ought to have. A will is very useful, of course, when you pass so that you left your wishes. Now, I want to tell you that wills do not avoid probate. A lot of folks don't know that. So your will has to go through probate so it can be proven that it was valid, that you were of sound mind, you weren't under any duress or undue influence from any beneficiaries, this sort of thing. So your will has to go through probate, and so you want to ask yourself, now some folks say a will's cheaper than a trust, and I'm not an attorney, we don't accept legal fees, this sort of thing, but some folks will say, I want to take the affordable route and get a will, and maybe you get a will for $300. You say, well, it's a lot cheaper than a trust and all that, but I want to make sure you understand wills do not avoid probate. So after you pass away, you have to go through the county court, and your beneficiaries do, and the executor in that. And then they have to notify everybody, too, that they can come contest the will. Maybe you have 4 children. Maybe one of them shouldn't get money. Maybe they have a substance abuse issue. Maybe they have a gambling addiction, something like that. Maybe if one of your kids would be harmed by receiving money, maybe you have a will, so you can say, I want the 3 kids that should get money to get money, and I want the 4th child not to get any money. So the problem with this is, when your will goes through probate, the kid that you don't want to get money, that shouldn't receive money, has to be notified that they can show up in the county court system and in probate court, and they can contest the will. And what we've seen happen before is sometimes the kids they're back in the estate, and so that's something that with a will could be a problem. Now maybe what some folks should do, not specific advice, your mileage may vary, and again, I'm not an attorney, this is not legal advice. Maybe you ought to consider a trust. And maybe a trust would cost $3,000. You say, well, Scott, that's a lot more money for a trust than for a will. Well, you could get what you pay for, too. So with a trust does not go through probate. It's supposed to say probate. So we don't have to go through the county court system to prove the trust is valid. We let sleeping dogs lie. The child that you cut out of the will for their own benefit, they don't get notified that they can go to court to challenge the trust because the trust isn't in probate court. With a will, you have a executor, and it should be a trusted child or perhaps your attorney, this sort of thing. With a trust, usually folks are using a revocable living trust, meaning they can make changes to it, and you can be your own trustee while you're living. And in the trust, you name a successor trustee, so who succeeds you when you pass away as trustee. The trustee is like the executor for the will, but the trustee on the trust, once you pass away, the successor trustee takes over, and they can start cutting checks and handling the estate. They don't get to reinterpret what the trust, they don't get to change the trust. They have a fiduciary duty to carry out what your wishes were in the trust. So when you have a will and you get it for the $300 up front, let's say, what if the probate expenses were another $2,700? You didn't save anything either. And I'm not here to be a shill for the estate planning attorneys. I'm just saying you might save money on the front end, end up paying it in the long run anyway, and avoiding the trust. These are just some figures that I tend to see. So maybe you end up paying $3,000 anyway, but you put your family through probate, and you had a whole big mess of a process. Also, when you go through probate, this is not a private process. The wills get published. You're going through probate court. This is not some sort of secret session. This is in our area. It's in Cook County Circuit Court, and so everybody knows what the kids got and how much they got. So there's no privacy there. And with a trust, you get privacy. You avoid probate. Something else that's neat about trusts is they protect your non-retirement assets while you're still living. So with a trust, you could do some different things. So some of that speaks to asset protection. So a trust has certain abilities to shield some assets. Now, some things that we don't need to put in the trust would be retirement accounts, life insurance, annuities. These things already have some legal protection. These don't need to be in the trust, okay? So we don't need to put those in the trust. What should we put in the trust? Not specific advice, your mileage may vary, and I'm not an attorney, I'm a financial planner. So we have some things that ought to be in trust, possibly your home. Especially, is your house paid off? Or do you have a lot of equity in your house? You don't want to get sued, and people nowadays sue you for anything. You don't want to get sued in civil court. You get a judgment and a lien placed on your house, and now you have your home equities gobbled up with the judgment and lien. So then you have your house could be in the trust, and it's still your house. It's just titled in the trust. So it gives you a little bit of shielding from lawsuits. Your vehicles. How about bank accounts? Remember all the non-retirement, non-life insurance, non-annuity stuff. So the house, the cars, the bank accounts, these could all be titled in trust. Something else that could be titled in trust would be non-retirement accounts. We call those non-qualified accounts. They're not part of a qualified retirement plan. So non-qualified accounts, like your bank accounts are take-home money. Your non-qualified account could be like an investment account that you started with take-home money, right? So these sorts of things, you title them in trust, and now they have a little more legal protection if you were to be sued in a civil lawsuit. What would somebody sue you for? I don't know. It's modern day nowadays, it seems like people get sued left and right for everything. So trust can do that there. And then there's some other things when we're talking about legacy planning. The worst type of money to leave to the kids and grandkids. What do you think would be the worst money to leave to the kids or grandkids? It would be tax-deferred money. So we talked about this in another video, but tax-deferred money is the worst money to leave to the next generation. This can be traditional IRA, traditional 401k, traditional 403b, deferred comp, thrift savings plan, TSP, SEP, Simple Keo, all these tax-deferred traditional retirement accounts. I'll just write traditional IRA, but we mean IRA, 401k, 403b, deferred comp, TSP, all of those. Traditional money is tax-deferred. You've never paid any federal income tax on it. Under the Secure Act of 2019, these traditional tax-deferred accounts have to be drawn to a zero balance in a 10-year period. And so you leave behind tax-deferred money. This is money you've never paid federal income tax on. It could be traditional IRA, 401k, and all the rest. You leave it to the next generation. Under the Secure Act of 2019, they have to take all the money out over a 10-year period. All the money they take is federally taxable to them. You can put your kids in a higher tax bracket. At the end of 10 years, the income stops abruptly, and by federal law, the account has to be to zero balance. Your legacy's been erased as if you're never here, and you created a whole bunch of income and tax problems for the kids. You got the kids into a higher tax bracket, and you also got them used to an elevated income for 10 years. It can kind of discourage them getting off their duff and doing something. At the end of 10 years, the income stops abruptly, and they may have signed up for a 30-year mortgage with a 10-year income stream. So the worst money to leave the kids and grandkids is tax-deferred. There are a couple forms of tax-free money you could leave. So tax-free money, we could leave them Roth IRA would be nice. That's tax-free to the kids and grandkids. Under the Secure Act of 2019, they can grow it tax-free for 10 more years after you're gone through an inherited Roth IRA, a little complicated, but we could grow that money tax-free 10 years after you're gone. So that would give them an incentive not to go run out and spend it. It wouldn't put them in a higher tax bracket. It wouldn't get them used to a higher income. They would have an incentive to grow this tax-free 10 more years to kind of keep their mitts off it. So tax-free 10 more years after you're gone. This can make them into investors, savers, and that rather than spenders, squanders, and taxpayers. Another kind of tax-free money you could leave to the next generation would be tax-free death benefit from life insurance. So if you have life insurance, there's a death benefit, and it's tax-free. Now, the tax-free death benefit, we can't just grow that 10 years tax-free the way we could with the inherited Roth. So your Roth doesn't become their Roth, but we do a direct transfer to an inherited Roth, and they can grow this Roth money tax-free 10 more years after you're gone. And the life insurance death benefits can be tax-free. We talked in another video about step up in cost basis too, so other types of money that you might leave to the kids or grandkids. A lot of people want to leave a paid off house to the next generation. Usually by the time you die nowadays, maybe your kids and your grandkids have their own house, so your house is probably not what they want, but you could leave a house. And let's say you bought the house for $100,000 a million years ago, and then now the house is worth $500,000. And you leave it to the kids, they get a step up in cost basis, their cost basis, they inherit it at your death. Don't gift it to them before you go. Don't put their name on your house. Don't do all that, what I call hillbilly estate planning, okay? The way for you to leave the house to the next generation is let them receive it upon your passing. They get a step up in cost basis, so they could turn around the next day, sell it, and all of this $500,000 is tax-free to them. If you gift them some ownership, maybe you're putting their name on there. A couple things. You're putting your kid's name on your house while you're still living. That can be determined to be gifting. It could eat into your estate tax exclusion. It could also all sorts of things. So if they get sued, if your kid gets sued, your house is their asset now, and they can come put a judgment and lien on your house because your child got in some trouble some way or another in a civil lawsuit. So don't put your kids on title. Don't gift them the house while you're still living. Let them receive it upon your passing, so they have a step up in cost basis. $500,000 house, they get a $500,000 tax-free asset that way. Now, there are other things we could talk about with charities. So if maybe you don't have kids, or maybe you don't like them, or maybe you like the grandkids better, there's all sorts of certain scenarios. But a lot of times, some of my favorites are charities. I like children's charities because you can fault adults for a lot of things, but the kids are innocent and they didn't do anything. A lot of good kids charities. Here in Chicago, we have the Mercy Home for Boys and Girls is a good charity, kind of an orphanage to give kids a better structure so they can have a successful life. So there's a whole lot of different kinds of charities. We could leave, say, our tax deferred money in our IRAs. If we still have some when we pass, we could name charities as beneficiaries, and then they don't have to do the income tax on that. And then the other thing we could do, let's say, this is something, I'm a big fan of doing something while you're still here, and right now, it's the tail end of 2023 as I record this, and you can do a $17,000 gift to anybody you want. Every individual can give every other individual $17,000 this year. There's no paperwork, there's no gift tax, there's no gift tax return. This is tax-free to the other person. Another thing you could do, and you get to see how the other person does with that money, and maybe you decide you don't want to give them any more money, and maybe you realize you take them out of the will or the trust because maybe they shouldn't get any more. Another thing you can do, you have a tax-deferred traditional IRA. You can do something called a qualified charitable distribution. So as you get into your 70s, you have a thing called required minimum distributions. The IRS makes you take a percentage of your IRA out every year, and it's taxable to you. What you can do is you can have a qualified charitable distribution out of your IRA. Now the money needs to go directly from your custodian, like your Schwab, Fidelity, these sort of folks, directly from the IRA, directly from the IRA to the charity. So it needs to be direct. Now your custodian, your Schwab, your Fidelity, whoever can write that check and send it directly to the charity. It can't go through your hands, okay? So from your IRA directly to the charity, your custodian, you may have a Schwab or a Fidelity or somebody over here is your custodian, they can send the check directly to the charity. And now you can do, on the qualified charitable distribution, you can do $100,000 a year that way. And now that can satisfy your required minimum distribution that the IRS wants you to make. So you could do up to $100,000 a year, qualified charitable distribution from your IRA to your charity, and that amount of money there can satisfy the required minimum distribution that would otherwise be taxable to you. So this would be taxable. If you took the required minimum distribution from the traditional IRA or 401k, it would be taxable, the required minimum distribution. Over here, you could do up to, doesn't have to be $100,000, you do up to $100,000 per year, qualified charitable distribution to the charity, and this is tax-free. This never touched you, and so you didn't generate any taxable income. And that's a nice way that you can benefit from charitable giving and reduce your taxes without having to itemize. That's kind of neat too. So there's a lot there to consider. So I hope we learned a lot today about legacy planning. We learned that wills do not avoid probate. Trusts do avoid probate. With a will, you have some front-end savings, some back-end expenses. It might be good to talk to your estate planning attorney, or we can refer you to one, and just talk to them about that, about the pros and cons of the wills and trusts. The wills, they leave a lot to be desired. The trusts have a lot, again, of asset protection characteristics where they can protect some of your non-retirement assets while you're still living and all that. So if you want to talk to us, go ahead down in the description. There's a link where you can schedule phone time with one of our financial planners. We can walk you through all of this and more, answer your specific questions, get your questions answered. So this has been Retirement Dakota with Scott Tucker. I'm your host, Scott Tucker. We'll see you on another video.